Okay, our final speaker of the day is the Honorable Edith Jones. At dinner last night, she said she favors brief introductions. The briefer, the better. So I'll keep to that guideline as best I can while still keeping in mind her many impressive accomplishments. She was appointed to the bench by President Ronald Reagan in 1985, and she became the Chief Judge of the Fifth Circuit in 2006, a position she held until 2012. She was awarded her JD at the University of Texas Law School, where she was a law review editor and received the Order of the Coif, C-O-I-F, and I confirmed the pronunciation with the judge last night at dinner. Judge Jones served on the board of the Sam Houston Area Council of the Boy Scouts of America for many years and received Scouting's Silver Beaver Award. I think that was back in the days when the Boy Scouts was still an organization for boys. She has been a member of the Garland Walker Inn of Court in Houston for many years and is its current president. And she currently serves on the board of the Calvin Coolidge Presidential Foundation. Her topic today is the rule of law and administrative law. Would you please welcome the Honorable Edith Jones?
Good afternoon. I have to say that after hearing about Russia and China and how to think about trade and so on, we're back to administrative law, and it's a rather dry topic. It was introduced to you last night from the standpoint of the political situation by Kim Strassel, who put about as much excitement on it as is possible. And then today, Larry referred to it a bit as well. I'm going to, my aim is modest, and unfortunately it's law-centered, because I'm going to try to put a little flesh on the bones of what it means legally to operate under the administrative state that we have today. But first, I want to say a word about Hillsdale. I was invited to teach there about 4 years ago. I've taught twice seminars for kids interested possibly in going into law school, and they were very, very good kids, very thoughtful, very interested in learning about the legal system as it ought to be, in my view. I was the teacher, after all. And I've now had a series of law clerks who did their undergraduate career at Hillsdale and then went on to very fine law schools. Whatever one may think about the quality of legal training in the United States, and I have some real interesting observations about that, the Hillsdale kids went in with their heads on and came out well-trained to practice and preserve our democratic republic through their legal training. So I'm very much a supporter of the Hillsdale enterprise and Dr. Arnn and the many faculties members I've had the privilege to work with. Well, so what is the problem with the administrative state? You've pretty much heard about that from Kim Strassel and Dr. Arnn, but let me start off by quoting James Madison. I believe there are more instances of the abridgment of the freedom of the people by gradual and silent encroachments of those in power than by violent and sudden usurpations. The rise of the administrative state has in fact silently and gradually encroached on our constitutional structure for approximately 100 years. I'm going to trace this history very briefly, outline the type of challenges it poses, and offer just a few thoughts about what needs to be done to reverse these encroachments. We start off, as we always must, with the framework of the Constitution. Article 1 commits all of the legislative power to the Congress, who are the people's representatives and tied to the people. Article 2 represents the president, who makes a commitment to take care that the laws shall be faithfully executed. So it is his job to apply the law and enforce the law through organs such as the Department of Justice. And finally, Article 3 is the independent judiciary, blessed with life tenure, which of course I didn't favor until I became a federal judge, and salary protection, so that we have the power of will and not judgment to say what the law is independently. However, you will see how effective those protections are. What was the purpose of the tripartite division of government, the separation of powers? As Dr. Arnn pointed out, it was to preserve individual liberty within a framework of law. There were 500 years of English history leading up to the American Revolution, during which Parliament or the Lords or whoever struggled to rein in the king's exercise of unilateral and unchecked power. The royal power was often exercised through crown courts and councils, which were unrepresentative bodies. They made and enforced the king's edicts, totally apart from Parliament, and they were predictably arbitrary and oppressive. The founders knew this, and this is why James Madison voiced the universal view of the framers when he said, "The accumulation of all powers, legislative, executive, and judicial, in the same hands, whether of the one, the few, or the many, is the very definition of tyranny." So we have the structural constitution, which is intended to have separation of powers to protect liberty, prevent arbitrary and oppressive government. This brilliant plan worked for over 100 years through political struggles, economic changes, civil war, and the demise of slavery. As of 1892, the Supreme Court could declare, quote, "that Congress cannot delegate legislative power to the President is a principle universally recognized as vital to the integrity and maintenance of the system of government ordained by the Constitution." What happened to this universal consensus? Well, as you know, the late 19th century posed a number of social and political challenges to the country. There was the rise of big business, mass migrations to the cities during the industrial age. There were social tensions and upheaval. But just as important, an intellectual challenge arose to the foundations of constitutionalism. Scholars like then Professor Woodrow Wilson had become enamored of the German ideas about progress, sovereignty, and government social responsibility. The Germanic system elevated social welfare above individual liberty, and it placed at that time what they said was a scientific, efficient brand of government management over government of the people and by the people. Honest, independent, expert administrators, the argument went, would rise above politics and pursue the best interests of the people. The progressive movement, which influenced both political parties at the turn of the last century, was heavily influenced by these people and these ideas. In fact, many progressive scholars believed that the Constitution's separation of powers was antiquated and inefficient, but they didn't tell the people that. As the progressives campaigned, they made their case to the public on more appealing grounds. Who could object to the government's acting through regulators and administrators to prevent railroads and utilities from price gouging and discrimination? Who could object to improving working conditions and ensuring safe drugs, meat, and food? Thus, at the beginning, through the efforts of the progressives, we saw the creation of the Federal Trade Commission and the Interstate Commerce Commission as our first major regulatory agencies. Interestingly, in the early years of their existence, they could not enforce their regulations. They had to go to the Article 3 courts to do that. Congress started passing these laws and delegating to agencies within the executive branch, And the agencies, in turn, were given the authority to decree regulations with the force of law. That means the administrative state was born. During the Franklin Roosevelt administration, as you all know, administrative agencies proliferated. And that may be why we call the presidential tenure in the modern era an administration. These were created in response to the Great Depression, but also because these progressives within the Roosevelt administration believed that ordinary politics could not solve the problems of government, and besides that, they didn't want the people to be bothered with too much. So we had the alphabet agency era, the FPC, the SEC, the CAB, the NLRB, the FCC, along with the FTC and the ICC and others, began regulating major sectors of the American economy. Again, apart from a few pesky Republicans and those who had felt the sting of regulatory enforcement, who was going to object to these agencies, who was arguing that the separation of powers had been violated. For a time, the United States Supreme Court did that. In a most famous decision, it overturned the National Industrial Recovery Act, the NRA, in the Schechter poultry case. And Mr. Schechter, the kosher butcher in, I think it was Brooklyn, had been prosecuted with the threat of being sent to prison because he was selling chicken too cheap. When that got to the U.S., and by the way, Felix Frankfurter, one of the great liberal-turned-conservative justices, was then advising the Roosevelt administration. He told them, don't pursue this case. It's not going to come out well for you. This was the classic David and Goliath struggle of the little man caught in the toils of administrative excess. Surely enough, when it got to the Supreme Court in Schechter Poultry, the justices started asking questions of the government and snickering during the argument. That was a tip-off. In Schechter Poultry, the court unanimously held that Congress had delegated its legislating power to the executive in an unlimited fashion. What called the non-delegation doctrine was violated, and the NRA was effectively dead. That is the last time the Supreme Court declared a law unconstitutional for violating the delegation principle. During the Roosevelt administration, statistics tell the tale of the growth of the administrative state. From the founding until 1900, 17 agencies were created with the power to determine private rights and obligations by rulemaking or adjudication. In the next 30 years, 1900 to 1930, the mostly progressive era, except for Calvin Coolidge, an additional 17 agencies were created. In less than a decade, from 1930 to 39, 18 more agencies took off. Wage and price controls during World War II, together with abuses perpetrated by these agencies, aroused the public and influenced even the Democratic Congress and president, and eventually public pressure led to the enactment of the Administrative Procedure Act in 1946. The APA is still in force today, still allegedly governs rulemaking and the actions of administrative agencies. In broad terms, the act was supposed to accomplish 4 goals. First, to keep the public informed of agency organization, procedure, and rules. Second, to foster public participation in rulemaking. That's a good idea. Third, to set uniform standards for rulemaking and adjudication. And adjudication is when an agency decides whether a member of the public has violated its rules. And finally, to define the scope of judicial review of agency action. Senator McCarran, a sponsor of the legislation, called the APA a Bill of Rights for hundreds of thousands of Americans whose affairs are controlled or regulated by federal agencies. As the framers knew, power without accountability devolves into authoritarianism. Accountability in their design arose from the rule of law and the separation of powers. Did the EPA standards achieve the goals of the legislators and legal accountability for administrators and regulators? Sadly, in my view, it did not. Take, for an example, the Occupational Safety and Health Act, which promulgates regulations for workplace safety. What I'm going to list is how an enforcement action proceeds under OSHA, but it is characteristic of the operation of almost every administrative agency. Number one, OSHA can come to a workplace without a warrant and look at all the records and workplace and examine that workplace to its heart's content. Number two, it can base charges on policy statements or interpretation of its own regulations that the regulated party or workplace owner may not have quite understood because they weren't clearly written down. Number three, based on this warrantless search and charge with no underlying discernible written policy, they can issue a citation and a fine. Well, what can the business do? He can go into court, but the court is an OSHA court, an administrative law judge. And what happens there? There's no jury. And the employer, instead of having the presumption of innocence, the employer has to prove himself innocent. He has to prove he did not commit. This is what the IRS does too, by the way. You have to prove that you don't owe the taxes. And what if you lose before the administrative law judge? Oh, you can appeal. To whom? The Occupational Safety and Health Review Commission, which made the unarticulated policy and authorized the warrantless search to begin with. Does this sound fair to you? Does this sound like the rule of law? But this is, in fact, under the EPA, this is the way most agencies are still allowed to operate. Well, what about the role of the courts in policing the agencies? That's a very interesting story. Let me read you the standards of review for judicial action. Courts can overturn regulations if they are, quote, arbitrary and capricious, an abuse of discretion, or otherwise not in accordance with the law, close quote. Does this sound clear to you? Well, you're laymen for the most part, but believe me, lawyers have struggled with the meaning of these standards, and in any event, they're clearly established to favor the administrators. So going into the courts, the regulatory body has a leg up on its interpretation of the law and the regulations and the procedures that it used. In addition, if the agency took its action by means of an adjudication, a trial-type proceeding, it can defend on the basis of, quote, substantial evidence. Well, here's another legal explanation. Substantial evidence is, quote, more than a scintilla, but less than a preponderance. So they can be completely wrong, but if it's more that the agency does not have to prove up the facts, even to the standard of a civil trial, much less to, the criminal standard beyond a reasonable doubt. So under the APA, and up until the late 60s, a vast amount of complex economic decision-making occurred within this agency framework. And I say economic because most of those agencies were regulating the organs of interstate transportation, utilities, communications, and financial services. As far as the standards were concerned, astute commentators like Judge Henry Friendly, who was the mentor of Chief Justice Roberts, complained that the open-ended and vague standards of judicial review resulted in conflicting and unpredictable decisions out of the courts. So the courts occasionally might have reversed regulatory decisions, but they certainly added to the length and complexity of the decision-making. Well, then we come to the era of Lyndon Johnson and Richard Nixon. Their administrations approved the creation of regulatory statutes and bodies that became oriented toward even vaguer objectives like risk reduction, social welfare, and the environment. Congress commissioned the FDA to approve drugs and medical devices. It created the EPA, OSHA, Consumer Product Safety Commission. It instituted auto safety regulations, authorized Medicare and Medicaid, which for the first time were regulating doctors and hospitals, and ERISA was passed to secure employee pensions. Regulators were granted virtually unlimited authority to engage in lawmaking, adjudicating, and penalizing according to their respective mandates. And to avoid the agencies being captured by the groups that were being regulated, Congress began adding citizen suit provisions. And of course, what is a citizen suit provision worth unless you're going to shift the fees to the citizens who win in the lawsuit? Created great enticement for even more litigation and delay. Just to show you how the inability of the courts to respond was occurring here, Justice Byron White addressed an administrative conference early in the 70s, and he pointed out in the 1960s, the Supreme Court received cert petition in about 60 administrative law cases each year, and it decided 30 of them. By the early 1970s, the number of petitions had increased to several hundred, but the Supreme Court was still deciding only 30 such cases. Today, I dare say it's deciding even fewer such cases, but the amount of federal regulation has mushroomed up. I would venture to say 7 to 8 times the volume of litigation that existed in the early 70s. So the courts physically can't keep up with the growth of the administrative state, even if we thought we could do something. Curiously, the Supreme Court, while pursuing judicial activism toward the Bill of Rights, began to adjust to the administrative state with inconsistent pronouncements. On the one hand, it opened federal courts to pre-enforcement review of regulations. In other words, it speeded up the process by which parties could enter into the federal courts and challenge regulations, and it instructed the courts to make a thorough, in-depth, probing review of the factual record underlying agency action. But I think far more important were a series of decisions that let agencies run according to their own devices or possibly run amok. In a pair of decisions around 1972, the court encouraged agencies or authorized agencies to go into what we called it a notice and comment rulemaking. And that is the kind of rulemaking where the agency files a public notice in the Federal Register. We're thinking of making a regulation that will, take care of whatever it is, some financial rule. And interested parties are given 30 to 60 days to comment. And then 120 days later, perhaps the agency comes out with its proposed rule. The parties can comment again, and then the agency promulgates its rule. It has very little to do with the actual legislative process as we would have through Congress. You have an agency that may or may, that sees its goal in life as single-mindedly pursuing such and such type of administration and doesn't take the holistic approach that Congress has to take in the ordinary democratic process. But notice and comment rulemaking was quicker and more efficient, and device, which is fine if you want to extend regulation, which is what the Supreme Court essentially did. They also had rebuked the D.C. Circuit. D.C. Circuit was in a frenzy of imposing additional requirements on this notice and comment ruling. They rebuked the D.C. Circuit for doing that. They told the courts that lower courts, you cannot second guess the basis when the agency goes out to prosecute someone. In other words, what we call prosecutorial discretion in the hands of the president and the DOJ, which is accountable politically. Prosecutorial discretion is a very important thing. In the hands of the agency, there's no political accountability because many of these agencies are deliberately structured to have no direct accountability through the president. And finally, in 1984, the Supreme Court issued the Chevron decision, which, if anybody's interested in, a room full of paper has been spilled over the benefits or detriments of the Chevron decision. But the bottom line was it told courts that we have to defer to an agency's reasonable interpretation of ambiguous statutory language. Well, all I can say about that is that Justice Scalia's career was devoted to the principles of originalism in the Constitution and textualism in interpreting statutes. And were it not for Justice Scalia, courts would be free to hold that every darn statute is ambiguous, and the regulators therefore had free run of the entire Code of Federal Regulations. It is only thanks to Justice Scalia, I think, who made every judge focus on what the text and context of statutes actually say, that in some occasions we were able to hold the agency to account against the law, like duh. But what happened, the bottom line here is that the Supreme Court, combined with these relatively latitudinarian standards of judicial review, deprive courts of the ability to rigorously review regulations. So again, what does this mean for the rule of law? Well, it seems pretty clear. And what happened, and how did the agencies react? Well, predictably, they have been able to, they've deliberately exploit ambiguities in regulations. If a statute is truly ambiguous, then they do have every ability to promulgate a reasonable regulation. Reasonableness is generally in the eye of the beholder, and most judges are quite reluctant to say that regulation was unreasonable. They are allowed to even bypass notice and comment rulemaking, and it became very common in the last 15 to 20 years to substitute even formal rulemaking with a fig leaf of public participation to policy statements. Why? Because the Supreme Court said that when an agency interprets its own regulations, we have to give great deference to that. Now, that's a principle that's coming under serious attack now, but at the moment, that's the law. So why bother with a rulemaking when you can just issue a policy statement? And as you all know, well, this stuff is called dark matter. And what's the impact of dark matter? Well, with such policy statements, the regulated parties know what they have to do so that they won't be hauled into a proceeding by the administrator. It's an offer that most regulated parties can't refuse. This also deters legal challenges and insulates the agencies from oversight. Predictably, the regulators went to excess. There are too many examples to name from the past decade, but I'll try a few. There was the guidance letter that forced high schools to consider adopting same-sex bathrooms. It was a Dear Colleague letter that motivated the educational institutions to abandon due process standards and seriously water down the definition of sexual harassment that you may have read about problems on college campuses. Conscience clauses protecting medical and religious personnel from federal regulations were abandoned. Under presidential influence, the executive agencies awarded exemptions contrary to the plain terms of the Affordable Care Act, so that special interest groups like moi, the federal judiciary, and Congress are exempt from Obamacare. And believe me, our premiums are a lot lower than yours are. And President Trump had threatened to take that special privilege away one time, and I can't imagine why he hasn't, but that's the way it is. Another example of special privilege, I mean, the arrogance of the agencies is quite astounding. The Consumer Financial Protection Board, which OMB Director Mulvaney took over a couple months ago, has built a $120 million building at prime property in DC. It costs $400 per square foot. And the article on it said that it looked more like an upscale headquarters, a camp, or a fancy hotel. This cost per square foot was more than Trump World Tower. The agencies also felt free to regulate, again, even beyond the statute. Kim Strassel mentioned this last night. One example was United Air Regulatory Group versus EPA, where they took a statutory threshold of 250 tons of air pollutant and turned it into 100,000 tons so they could further their interest in regulating greenhouse gas. It was pretty not difficult, although it was a 6-3 decision of the Supreme Court, to say an agency can't rewrite numbers in a statute. For 20 or 30 years, the IRS has been evading laws that require agencies to provide cost-benefit analyses of their regulations. And finally, preparing for these remarks, I read an article in the Administrative Law Journal, which goes out mostly to people in the administrative agencies, commenting that a dominant tendency in public administration training today is simply to disregard the rule of law issues. And the author says, hopefully, I think this is something that administrators really ought to think about. In other words, that they're working for the people under the rule of law. So on another level, regulatory agencies began overturning decades-old precedents in order to fashion policy. These kinds of actions have led to great uncertainty, which undoubtedly had an impact in deterring economic growth recently. Suffice it to say, and I think you've already gotten some numbers here, just for an example of regulatory groups going crazy, in 2015, the federal government promulgated over 3,500 rules, and in 2016, over 3,850 new formal regulations were issued. I think this really came home to a lot of the American people when the Supreme Court decided the Sackett versus EPA case. The Sacketts had bought a 2/3 acre parcel, I think in Idaho or Utah near a lake, to build a retirement home, and EPA swooped down on them and said, this is a wetland. Well, they were above the lake. But they were doing some fill work and said, this is a wetland, and if you don't stop this, you're going to get sanctioned $10,000 a day. And hey, you can't go to court. Well, fortunately, the Supreme Court said due process hasn't been totally abandoned, and that they had the right to fight the propriety of this decree in court before they might actually have to pay $10,000 a day. So from all these standpoints, the administrative state has expanded with little control being exerted, even during the Bush and Reagan both Bush and Reagan administrations. And as this has happened, it has also eroded the actual tripartite organs of our federal government. In other words, Congress has become accustomed to delegating more and more unaccountable power out to bureaucrats. And there are many reasons for this, but just a couple of really troubling examples are in the Sarbanes-Oxley bill, they created the Public Accounting Oversight Board, the PCAOB, the constitutionality of which went to the Supreme Court. Why? Because they insulated that by 2 levels from the appointment authority of the president. Why did they do that? They did it so that that board would not be politically accountable for the accounting standards it was setting up. Dodd-Frank may have epitomized the idea of delegating regulation amok. It sent instructions to a couple of dozen different federal agencies. So far, over 100,000 pages of regulations have been issued in pursuance of Dodd-Frank. One private research institute found that for an affected business to learn how it needed to comply, it couldn't ask anyone to read the regulations. It had to do a computer word search. Now, the rule of law means that the law has to be intelligible at some level, and I would say that if you need to do a computer word search to find out how often your local financial advisor has to fill out forms to comply with Dodd-Frank, something is seriously amiss. The rule of law has been forfeited. Congress had every reason to know what it was doing. But so the practice of legislating has been eroded. The court's oversight of administrative state can hardly keep up with the volume of new regulations. We are hindered by the current EPA standards and by the decisions I have told you. More than that, there's a problem that Tocqueville noticed about lawyers, which is that he called lawyers the aristocracy of the United States. And at one time, I used to naively think that was because we were so learned and well-trained. But there was another side to his comment, and that is that lawyers are most inclined to favor the status quo and to be happy to work with whatever executive power there is, and that includes the presidential power and whatever the status quo is in the organization of government at a different time. Well, judges are of the same breed. So I've already told you how the executive branch has fared during this time. On one hand, the administrative agencies have become bloated and very much profited in terms of being able to act independently and without accountability. On the other hand, there are so many people within those agencies, as Kim Strasser was describing, that a new president can hardly keep them under control. And in fact, in many instances, they're able to pursue their own devices in resistance of the executive administration. What can we do? Well, there are a number of things Congress can do, and various statutes have been proposed to even reform the 76-year-old or 71-year-old Administrative Procedure Act. Several of these pass the House of Representatives and then die in the Senate. A real easy answer would be just to cut the budgets of regulatory agencies, which is something that I've suggested to scholars sometimes, and they just sort of roll their eyes. How naive can you be? But you know, if you don't have as many employees, you're either going to have to focus on your mission or else make it plain that that you are not acting in the people's best interests. They could continue to aggressively use the Congressional Review Act. I will shout out my former law clerk, Todd Gaziano, who worked for Congressman David McIntosh to pass the Congressional Review Act 20 years ago, and until January of last year, it had only been used once to stop the enactment of extreme regulation. There's another measure called the REINS Act, which is pending. I do note that regulation of these when I mentioned the utilities and the interstate transportation regulation, eventually the public and even the knowledge classes became so aware of the impediment that administrative regulation, the shackles that it was placing on competition in railroad and trucking and air transport, for instance, that eventually Congress deregulated. So Congress could, in fact, deregulate once the public pressure gets strong enough. What can the executive do? Well, you know, this president has been doing more to take control of administrative agencies than any president ever. Now, that may be because there's so much more to take aim at, but he required that agencies repeal 2 old rules for each new one. He's required he's made appointments to a number of these boards that has created more of an ideological balance on them. Recently, through the Justice Department, they said that agencies are not going to be allowed to promulgate major policy through mere statements, that they have to undergo the rulemaking procedure instead. I don't know precisely the breadth of that, but that would be a very important one. They have revised rules that or withdrawn some of the rules that were in process during the previous administration and said they were going to reconsider them. OMB Officer Mulvaney provided a statement of principles for the CFPB, the Consumer Finance Protection Board, which was one of the worst, that could be adopted by every agency. And among his it's published in the Wall Street Journal, he says, "We are government employees and we work for the people. That means everyone, those who use credit cards and those who provide credits, all of those people are part of what makes this country great, and all of them deserve to be treated fairly by the government. It is not appropriate for any government entity to push the envelope when it comes into conflict with our citizens. On regulation, it seems that the people we regulate should have the right to know what the rules are before being charged with violating them. This means more formal rulemaking, and we will begin prioritizing in our enforcement." Now, if that kind of mission statement were imposed on every administrative agency, it would make a world of difference. It would also require the culture of the administrative agencies to change. And finally, the courts. Well, I've told you what's the negative as far as the court's response to the administrative state. But I will say that a significant academic challenge is now being made to the threats that arbitrary administrative rule posed to the separation of powers and due process and the rule of law. Professor Philip Hamburger wrote a very well-known book called "Is Administrative Law Unconstitutional?" Came out about 4 years ago. Very long book, very, very thorough scholarship. It was immediately greeted with horror and ad hominem attacks by many of the so-called administrative law experts in the professorial community, but it's been cited favorably by Justice Thomas and Justice Gorsuch. So these ideas, there's scholarship that is going after nearly every one of the principles of deference that I told you about. And although I do not regard courts as the ultimate solution for the problem of the administrative state, courts will have to begin looking a lot more seriously at the extent to which agencies are properly applying the law that governs them. And finally, there's the battle of ideas. And it was the battle of ideas that led to the creation of the administrative state to begin with, although it came under somewhat false colors. But it will be the battle of ideas that will win in the end. There are a lot of professors, there are think tanks who are involved in this. Professor R.J. Pastrito here at Hillsdale has done quite a lot of writing and effective scholarship on this subject. There are many young academics who are being trained in part by clerkships in the federal courts that lead them into some academic positions. And I would urge that such scholarship has to become digestible to the public as well. The ultimate answer, it seems to me, I always look to Justice Scalia for originalism and textualism, and to Ronald Reagan, who said, "There are no easy answers, but there are simple answers. We must have the courage to do what is morally right." Thank you.
Thank you. Please raise your hand if you have a question, and the mics will be brought to you.
What is the judicial justification for the agency being prosecutor, judge, and jury? And have the courts addressed that, and what's the pretext, the explanation?
That is one of the mysteries of the history of administrative law, and you have to look at each part of that. I was just reading articles recently about it, and it started with the Interstate Commerce Commission, which had the power to regulate railroads but couldn't enforce its orders. And the public were getting very upset. You remember, this is the time when the small communities felt that they were being cheated by the railroads, charging too high a rate from the agricultural areas into the cities and so on. The public became very disaffected with this. The Supreme Court was looking closely and overruling a lot of attempts by the ICC to engage in regulation. And the thought is that at some level, the court decided that regulators ought to be able to look at the facts underlying a decision, and that the courts ought to defer to the way in which the regulators had found the facts. Now, there are a lot of issues that went sort of under the radar, and about the non-delegation doctrine, as I said, got killed. That got killed largely because a couple years after Schechter-Poultry, may have been at the same time, was Roosevelt's court packing plan, and the membership, Roosevelt eventually appointed, I think maybe all members of the Supreme Court, but enough came on in a critical 2-year period that after Schechter-Poultry, the court began approving everything. So the non-delegation doctrine died because Roosevelt put all his new dealers on the Supreme Court. And it never really came back because it's a difficult, scholars have had and judges have had a difficult time grasping it. It's very, what is an appropriate delegation and what isn't. I don't know that that'll be challenged, but a lot of this around the edges, like how do you make a rule? How do you really what Congress ought to do is write statutes that said, we want you to regulate, well, it did in the EPA, pollutants. And then it listed some pollutants, and I forget whether there's a catchphrase or not, because there's so darn many of those statutes. But the Supreme Court really went, you know, way over generous in interpreting that law when it said that you could regulate greenhouse gases, okay? And that means that that gave the agency the courage, the brazenness to pursue, you know, under this last administration, the greenhouse plans. But Congress never specifically said that. In fact, Congress would not have passed such a law.
I want to tell you something the EPA did, since you mentioned them again, to a dear friend of ours, and it shows how these government agencies destroy people. This man runs a 75-year-old family business. For 5 years, he ordered a chemical with all these forms he needed to fill out, was never told he did anything wrong. After the 5th year, the EPA shows up in his office. You are breaking the law. You are buying more chemicals than you need. We're coming after you. For 2 years, they made his life a living hell. They went to his secretary's house in the dark with guns, EPA agents, to coerce her into giving them bad information about their boss. He was furious. He finally, after the stress was unbelievable, it was in the newspaper. He is a college graduate. His wife is on a hospital board. They give money to the hospital. He works with Junior Achievement. He's an Eagle Scout, a good citizen, employs 40 people. But he finally, after he paid them a fine of $500,000, everything was good. He could order his chemical again, and he was good for 2 years. However, he was a convicted felon, so he had to get rid of his Civil War gun collection. He had to call his parole officer every week. He could not leave the country. He had a vacation home out of the country. Couldn't do anything. This is ridiculous. 2 years later, they show up again. They find another thing that was totally stupid. They put him through the same crap again. Excuse my words. He's a very good friend, and this is very upsetting. 2 years later, they come back again. This is the third time. Now our friend is in the hospital. He is so ill, the doctors do not know what is wrong with him. But I'll tell you, it is the stress that our government has put on him. They are killing him. His wife is falling apart. The man said to us once, I might expect this in Russia, but not in the United States. They are destroying my business. My husband wants to get him a pardon if he can. We tried under when Bush was still in office, and our congressman who was here last night said it was too late, couldn't do anything under the Obama administration. What can we do to help somebody like this before he dies so he doesn't die a convicted felon?
All I know of is the presidential pardon power. I'm sorry. I mean, that's, that ought to be a matter of great public concern. Again, I mean, when the kinds of cases we get before the Supreme Court or before our court are not those cases because those people can't afford the sophisticated legal talent that it's required. The Sackett case was supposed to avert some of that. So I don't know when your friend's problems arose, but I agree. It's unaccountable political power, and it's unaccountable political power in the hands of one agency.
Aye. A few years back, the Supreme Court decided to change the meaning of the word marriage. Now, all the laws are actually written in words. If the Supreme Court can change the meaning of one word, do any of the laws actually mean anything anymore?
Well, as you know, that was a 5-4 decision. And the Supreme Court can do a lot of things with 5 votes. And I am not standing here to justify everything they do. If they adhered to the principles that Justice Scalia stood for, that Justice Thomas stands for, that Justice Alito stands for, that God willing, at least 2 other members of the Supreme Court stand for, that kind of thing wouldn't happen. You know, that's the downside of life tenure for judges. But the point of Justice Scalia's jurisprudence and philosophy was that judges in our society have one right and one duty, and that is to say what the law is, and the best and only evidence of the law is the text of the law. So whenever you read about a Supreme Court decision, the press reports them in terms of who won and who lost, but you can always say what was the law, and that ought to give you the answer, and it usually does.
Time for just one more question.
Thank you. I'm a layman, not a lawyer, but I've actually read the Chevron decision and found it very puzzling. And I wonder maybe if you could shed some light on if you have a situation where a law could reasonably be interpreted to mean either A or B. I mean, how can a citizen be expected to know what that law means? And why didn't the courts just kick it back to Congress and say, if we can't tell us, pass a law, tell us whether it means A or B?
Well, that's a principle called vagueness, and the courts have been very reluctant to strike down laws as being unduly vague. I don't remember precisely what the statute was in Chevron, but it was one of those economic regulatory statutes. Let's say it was the Clean Water Act, and it said that waters of the United States. Now, if you look to the history of waters of the United States, the federal government had control over navigable waters of the United States, which certainly did not include most, inland marshes. It did not include seasonal streams and that kind of thing. And the court, trying to interpret that, made a stab at it about 10 years ago in the case called Rapanos that didn't quite solve the question, although it did. In that case, the EPA was trying to regulate a marsh that was totally inland, not connected to anything, if I recall correctly, and they said, no, that's not waters of the United States within the federal purview. States could regulate it, but not the federal government. But the administrators came back and used a very, think of a culvert, right? A storm sewer. Is that waters of the United States? Well, it depends on what regulator you ask, and the Supreme Court, it's an ambiguous. Unless you look at it in a purely historical sense, you could say it's ambiguous, and that's where people divide in interpretation. You can either look at something according to the dictionaries, according to the context and the history, or you can just take the words as if you're, a Martian coming down from outer space looking at this strange language. Waters of the United States. Oh, well, there's Jones's backyard in Houston. It's sort of damp, like everything in Houston. That must be waters of the United States. So that's where the ambiguity is, and then the question under Chevron is whether it is a reasonable interpretation. Under Justice Scalia, the Supreme Court did, in fact, look more closely at the statute, and it looked more closely at reasonableness, but the lower courts and even the Supreme Court are deeply divided. They're not consistent. The courts for a long time have acted as if we are the ultimate guardians of the people's liberty, and if I had one somber thing to end with today, it would be that you can't trust the courts either. Yep. Well, and I'll say it's not that we're not trying and that we're not dedicated, but the law is imperfect and judges are imperfect. There we go.